Hello, I'm Melissa Carlton, an attorney with the Bricker & Eckler Education Law Team. Today's Bricker briefing is on Bostock versus Clayton County, Georgia, a case that was decided by the U.S. Supreme Court on June 15, 2020. This case involves Title VII of the Civil Rights Act of 1964, which prohibits employers from discriminating against employees on the basis of race, color, religion, sex, and national origin. The court's decision focused on the definition of the word sex. Specifically, the question before the court was, if an employer terminates an employee on the basis of the sexual orientation or transgender status of that employee, does that constitute discrimination on the basis of sex, as prohibited by Title VII? The court ruled that it does. Justice Gorsuch, writing for the six-justice majority, stated it plainly. An individual's homosexuality or transgender status is not relevant to employment decisions. That's because it is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. The decision gives a number of examples to illustrate the court's point. In one, Justice Gorsuch tells the story of an employer who makes it a practice to fire all homosexual employees. If a model employee were to introduce the employer to that employee's wife, Susan, at the holiday party, whether that employee gets to keep their job depends on whether the employee is a man or a woman. Likewise, Justice Gorsuch relates the story of two employees, both of whom identify as female. One was identified as a male at birth, and the other was identified as a female at birth. If the employer terminates the first and retains the second, the employer is penalizing a person who is identified as male at birth for traits or actions that the employer tolerates in an employee identified as female at birth. This, the majority ruled, shows that the individual employee's sex plays an unmistakable and impermissible role in the discharge decision. The court held that Title VII is violated whenever sexual orientation or transgender status is considered in terminating an employee, even if the employer makes it a practice to terminate all LGBTQ employees regardless of their sex. The court noted that it was not asked to consider the interaction between Title VII and the religious convictions of employers, such as those religious organizations that receive an express statutory exception under the law. While most employers will need to adopt the new definition of sex immediately, religious employers should consider seeking legal counsel where such definition may conflict with fundamental religious tenets of their practices. Schools and colleges that accept federal funding may also have additional obligations as a result of this decision. Courts have previously relied on Title VII case law to help define the parameters of Title IX of the Education Amendments Act of 1972, a federal law that prohibits educational entities from discriminating against students, employees, and others on the basis of sex within their educational programs and activities. As a result, it is very likely that courts will read this new decision as establishing a definition of sex for purposes of Title IX as well. What does this mean on a practical level? Well, school districts in the jurisdiction of the U.S. District Court for the Southern District of Ohio, which covers the lower half of the state, have some direction thanks to a previous court decision known as Highland Local School District versus U.S. Department of Education. In that case, the court held that a school district's failure to allow a female transgender student to use the bathroom corresponding to her gender identity was a violation of both Title IX and the 14th Amendment's Equal Protection Clause. As for school districts in the Northern District of Ohio, there is not definitive case law yet. Those in other jurisdictions may or may not have case law governing their jurisdiction. Those in other states and those whose schools are found within the borders of municipalities should consider whether specific state laws or local ordinances offer any guidance on these issues. The U.S. Department of Education had previously issued guidance on transgender students and everyday issues such as bathroom usage and name changes in student records, but this guidance was withdrawn in 2017. We may see new guidance on this topic, but even if they choose to prepare it, we may not get it for some time. In the meantime, schools and colleges alike should consider taking the following actions in consultation with legal counsel. Number 1, modifying non-discrimination statements to include sexual orientation and transgender status as protected categories. Number 2, similarly revise non-discrimination and anti-harassment policies. And number 3, think about how to operationalize this within your community, and consider whether it is appropriate to prepare non-discrimination training to prevent bullying and harassment on these matters. We will be considering the impact of this decision on the new regulations in our Title IX training series, and we will post more information on this decision and related guidance in our Title IX Resource Center as it becomes available. Please visit www.bricker.com/Title IX for more details. Thanks for tuning in today, and we'll see you again soon.